on? Good afternoon. It's 2 o'clock on Saturday, August 10, 2019, and we are here at the State Bar of California for a public hearing to receive testimony on options for regulatory reform under consideration by the Task Force on Access Through Innovation of Legal Services. I'm Justice Lee Edmond, and I serve as chair of the task force. The task force is charged with identifying possible regulatory changes to enhance the delivery of and access to legal services through the use of technology, including artificial intelligence and online legal service delivery models. Any task force recommendations must balance the dual goals of public protection and increased access to justice. We are very happy to see you all here today. We've made every effort to get word of this hearing out to the interested public, including the media, through media and social media. This public hearing is being webcast. In addition, the proceeding is being audio recorded and transcribed by a certified court reporter. We thank you. Please speak clearly and project into the microphone at all times. Begin by stating and spelling your name. And by the way, this includes to anybody in the task force. I'm not sure that we will be speaking, but if any of you do speak, please state your name and spell it as well. And this is important for two reasons. It helps assure that your testimony is properly attributed to you, and it will serve as a sound check for the court reporter. Please limit your testimony to about 5 minutes in order to accommodate all anticipated speakers. This public hearing has been authorized by the Board of Trustees of the State Bar, which oversees the work of the task force, and the transcript of this public hearing will be made available to the members of the board. If there's anyone here who hasn't yet signed in or otherwise informed State Bar staff today about an intent to speak, then I ask that you sign in now before I call for the first speaker. And you'll see Lauren McCurdy, who's over here on our far right. And if you have any written materials that previously have not been submitted, please also give them to Lauren McCurdy, who is there to receive them. Supporting written materials will become part of the public record of this proceeding. In addition to this public hearing, a 60-day period to receive written public comment on the proposals is currently in process. The deadline for submission of written public comment is September 23, 2019. At its July 20, 2018 meeting, the Board of Trustees received a legal market landscape report by our illustrious consultant, Professor William Henderson, who's actually with us here today. Professor Henderson, you want to give us a wave? Thank you. After acknowledging the significant unmet needs of substantial numbers of members of the public in accessing legal services, in part the report states that ethics rules and the unauthorized practice of law are the primary determinants of how the current legal market is structured, and in certain ways constrain innovations that would provide greater access to and enhance the delivery of legal services. In response to the report, the task force has been studying options for possible regulatory changes to enhance the delivery of legal services through the use of technology and innovative legal service delivery models. In consideration of these options, the guiding principle has been striking the right balance between public protection and increased access. The task force is mindful of the risks of inadvertently creating a second tier of justice. However, online services are presently in the market and are largely unregulated. The task force has developed broad concepts for possible reform in the areas of the unauthorized practice of law, non-lawyer ownership, and fee sharing with non-lawyers. The task force has not endorsed any particular approach at this time, and in fact, some proposals are posed as alternatives. The task force is interested in hearing from you today to help us further evaluate these concept options. I'm now going to ask that the members of our task force who are with us here today just briefly introduce themselves. We'll start with Joyce Raby, go around to the end, and then come back this way. Maybe go around that way, maybe make it easier.
Do you want me to spell her name as well?
Sure.
So Joyce Raby, Joyce, Joyce, Raby, Raby. I'm the founding executive director for the Florida Justice Technology Center.
Toby Rothschild, Toby Roths, Counsel on Justice.
Hi, Dan Rubens, RUBINS, from Legal Robot.
Joanna Mendoza, Joanna Mendoza, Mendoza. I sit on the Board of Trustees, and I'm the Assembly appointee to the task force.
Lori Gonzalez, Lori Gonzalez, and I'm with Rayna Corp. Rayna Corp, Rayna Corp.
I'm Johan Drolshagen, JohannDrolshagen. I'm the CEO of Brickhouse Security Consulting and a member of the Washington State Bar.
Alan Rodriguez, ALLEN, RODRIGUEZ, founder of 1400.
I'm sorry, founder of what?
1400.
Bridget Grammy, BRIDGET, GRAMME, and I'm the director of the Center for Public Interest Law at University of San Diego Law School.
Jean Clausen, JeanClauson. I'm the Director of Network Relations and Legal Industry Advocate with ARUG Legal.
Abhijit Chavan, ABHIJEET, CHAVAN, from Tyler Technologies. Tyler Technologies, TYLER, Tyler.
Hi, Tara Bird. I'm a California attorney, and I'm also on the leadership of the California Lawyers Association.
Hi there, everyone. Andrew Arruda, ARRUDA, serving as the subcommittee chair of the MDP ABS group here with the task force, CEO and co-founder of Ross Intelligence. I also serve on the board of ISLES.
Kevin Moore, KEVIN MOHR. I'm a professor at Western State College of Law in Irvine, California, and the former reporter consultant to the California Rules Revision Commission.
Greg Fortescue, GREG, and last name is FORTESCUE. I am a lead attorney for the California Supreme Court and liaison to the task force.
Thank you. We skipped over the members of the State Bar staff who are with us. Let me just ask you very quickly to introduce yourselves.
Donna Hershkowitz, State Bar staff.
Lauren McCurdy, LAUREN, MCCURDY, State Bar staff.
Randall Diefentorm, State Bar staff, RANDALLDIFUNTORUM.
All right, thank you very much. And Lauren, let me ask you if you would please to call the first speaker.
Okay, hi. My name's Cynthia Chandler, CYNTHIA, and then Chandler, CHANDLER. I'm here to speak on my own behalf today. My organization is working on formal written contributions. I'm the director of the Bay Area Legal Incubator, which is an accelerator community coaching attorneys in building modest means practices serving low and middle income communities. Doing that by providing coaching on technology efficiencies and how to market in the new economy. I also want to say that I teach a course called Practice 99 on serving the 99% disenfranchised from legal representation because of either cost or geography at Berkeley Law School. And I also have the unique experience as an attorney of working in an area where I was coached and trained and mentored by non-lawyers who have permission to practice law. I'm a prison lawyer. Almost all of my mentors were prison jailhouse lawyers who coached me. I have deep regard for the capacity of non-lawyers to practice law. And I have trained over 1,000 people in prison in California on human rights law and post-conviction relief. So I say this because I have a deep regard for the work of your task force. I think it is essential that we bring up the capacity of attorneys to work in our new economy and in partnership with technology companies, who I see as partners in my incubator. It is with deep regret that I say that I am also very deeply opposed to the regulatory suggestions that the task force has put forward. The reason I am is because I'm concerned that there is a lack of regulation provided. And I don't mean details. I do appreciate that the plan is to move forward with a later task force on regulation. I also think that it is imperative that when you're thinking about opening up a business sector, to use that moment as leverage to have some bite in regulation that would be impossible to push forward later. I think it's unrealistic to think that we live in a political environment that is regulatory friendly. Okay? And I think it's essential that we have some bite now. At minimum, I think that the task force recommendation should be amended to mention that we must have and some sort of system for ensuring elimination of bias in artificial intelligence as it is developed, particularly around criminal law, family law, and other arenas where we know that bias has radically affected decision-making in the legal sector. This is not a radical thing. There was even a 60-minute section on this like 2 weeks ago. There was not a single mention of this problem in the task force recommendations, which was shocking and alarming to me. Similarly, there was no mention that the regulations must mandate that the technology be accessible to people with disabilities. That seems like, on its face, a glaring omission, again, completely absent in the recommendations as they were put forward. We can't disassemble our brick and mortar foundation of access to legal service and replace it with something that's inaccessible. We also need to ensure that marketing ethics are the same for companies moving forward with technology as they currently are with lawyers today, as well as, I think, making sure that technology companies cannot waive liability in their terms of use the way that lawyers cannot just simply waive away their competency in a retainer agreement. One of my colleagues went to try to set up an account at donotpay.com to check it out, which is one of the leading technology sort of like poster children for using artificial intelligence for legal representation. Before you can even see the terms of use, you're required to enter in your bank account number, okay? Do Not Pay on its face would be a name for a company that would violate California legal ethics requirements because it states almost a guarantee that you're not going to have to pay. It would be an unethical name because it would be predatory on consumers. Additionally, they do, in fact, have waivers in their terms of use requirements. I'm giving this as an example of what we should not have. If this task force is serious about protecting consumers, we should ensure that we are, in fact, protecting consumers. That kind of model is shockingly deficient, and we shouldn't replicate it. Additionally, I'm concerned that the proposed regulations would, in effect, deregulate lawyer referral services. Training new lawyers, I can tell you that the only attorneys I am worried about in terms of their ethical competency, or their competency and their ethics, are people who are so arrogant that they cannot self-reflect on what their deficiencies are. And sadly, every profession has some of those folks. Lawyer referral services now have competency requirements that help shield the public from bad actors like that. And we have to ensure that moving forward, any technology company that's generating leads and doing referrals also has to have baseline regulations around competency. All of these things are in place to ensure that attorneys do not abuse consumers, and we should make sure that that's extended. And I think it's totally inappropriate to imagine that this will just happen again. And finally, I would say that one of the reasons I think it's inappropriate to think that this won't happen if we just move forward without putting it in these regulations is actually even looking at just the advertising for this task force. I have to say that labeling more than half of you as community members, saying that there is a mandate that you're in that role in order to protect the interests of the public, assumes that business leaders are the same as folks who protect consumers. That is not actually the same. So when I heard that the task force was composed, half non-attorneys or more, because there was this mandate to protect consumers, I thought, oh, that's very interesting. Let's look at who those folks are. And half of you were labeled in public materials as being community members, which you are, in fact, as business leaders. And that is false advertising. So I don't think that this group should move forward with the task force in its current formation. I think you should be mandated to add on some folks whose sole job really is consumer protection and whose sole job is about disability access and AI bias, and that some additional voices should come into this task force to reshape those recommendations before you do your next round. And I'll just close by saying I really enjoyed Professor Henderson's research. I wish that this task force had spent some time on the half of the research that was about the need to retool attorneys. Perhaps the smallest, easiest thing your task force could do would be to ensure that attorneys can get MCLE units for marketing training and to retrain them in technology so that our profession does not become obsolete, but so that we can move forward and, in fact, provide services to more people who are currently disenfranchised. Thank you.
Thank you very much.
Good afternoon. I'm Ralph Baxter, and I am delighted to be here, and I applaud this open hearing and giving the people of California a chance to respond. By way of introduction, I've been a member of the California Bar for 45 years, and 40 of those years I spent in a large law firm, Orrick, which was founded here in San Francisco in 1863. I spent 23 of those years as chairman of the firm, and then 5 years ago, I moved into the rest of the world. And I've spent all those years in big law thinking about what is the best way to deliver legal service. And the 5 years since leaving Orrick, I have spent learning about parts of the ecosystem of law I didn't know very well. I've joined the boards of several legal technology companies. I've learned a lot about smaller law firms. I've learned a lot about delivering legal service to individuals of low and moderate income, and I've learned more about legal education other than having gone through it myself. And what I'm about to say about your proposals is quite general, and it is born of those experiences. And then finally, I'm speaking on behalf of myself. This is not the Orrick view or the view of any of the companies on whose boards I serve. And I want to start with this. Law is more important than it ever has been. It is in the lives of every individual, and it is in the lives of every business, every not-for-profit, everyone. And so the people, all of the people and all of the businesses of California depend on a legal infrastructure that delivers to them competent, reliable, trustworthy legal service. That's why I'm here today. I think there are three elements of your recommendations that are particularly important to me: 2.1, 3.1, and 3.2. Our current legal system does not meet the needs of those who depend on it in a satisfactory way. Our current legal system is too slow, it is opaque, it's not transparent, it's hard for people to understand, even sophisticated participants in law, and it is too expensive. And most fundamental, 80% of low and moderate income people do not have access to legal service at all. Those are the facts. I don't think that's at all in dispute. The rules of the California Bar erect barriers that impede modernization. So our system needs to modernize. Sometimes people think that it needs a bell or a whistle, a particular technology, and that will solve everything. That's not what we need. We need to modernize the way we do things. Take advantage of new ideas, new processes, new technologies, all of it. We just need to do it better. There's a lot of talk all over the United States and certainly in California that we are modernizing legal service, and we are. But we're doing it in a very slow and hampered way. And one of the reasons, and only one of them, that we're not modernizing faster is that the rules of our law practice in California impede modernization. And there are two particular ways that I want to emphasize today. One is that we limit the scope of professionals who can participate in delivering legal service. We limit it only to those who are licensed to practice law, and that means they went to law school and spent all of that money and all of that time to get ready. The other is that we only permit the lawyers to invest in the legal service firms. And both of those create problems. Not letting other professionals participate makes legal service more expensive than it needs to be. And it really makes the legal service less effective because it eliminates, it excludes from the conversation about how to do it best people with different perspectives, different training, different skills than those that the people who went to law school obtained. There isn't a business that's successful in the United States that doesn't want a workforce that consists of people with diverse training, diverse expertise, not just supporting the work of the business, but doing the work of the business. And our rules say we can't have that. They all have to be from the same narrow training, which is essential. And let me say, as I get to this part, I'm proud to be a lawyer, and I have the highest respect and appreciation after 45 years of doing this for what our lawyers do. That's not what I'm suggesting here. It's just that we can do better if we let more people with more diverse backgrounds play a role in what we do. Limiting who can invest means that the small firms, and I'm really concerned mainly about the firms that represent individuals with day-to-day legal issues. Those are the ones that are not getting served. The person with a landlord-tenant dispute, the person with an immigration problem, a family law problem, those issues don't have huge dollars associated with them. And it's hard to run a legal service business with clients whose issues don't have high dollar stakes, clients who don't have a lot of money themselves. That's a sustainable business. That's part of why it's so hard for people, individuals, to have access to justice. If we permitted some investment in the legal service enterprises, it would address that problem. Wouldn't solve it, but it would address that problem. The preliminary recommendations, 2.1, 3.1, 3.2, I think go in the right direction. They are clearly preliminary. They are in the section 3 parts are in the alternative. But my point today is that they go in the right direction of liberalizing who can participate and who can invest, and thereby how capital can be raised. I know there are concerns, and they're legitimate, about risks to the public. Once we start changing the rules, expanding who can participate, then, of course, there are some new issues to consider. But I have no doubt, I do not think this is really controversial, that we can come up with a regulatory scheme, who does the regulating and what are the rules, to protect the public. And the fact is, we are not presently protecting the public. When such a high percentage of our people don't have access to legal service, we're not protecting them. So I encourage you to proceed with this work. I encourage you in particular to find ways to expand who can participate in the legal service, who can participate in contributing capital to the effort, and come to a sound solution. I think the only mistake that you could make is to do nothing. Thank you.
Thank you very much.
Good afternoon.
My name is Andrew Perlman, Andrewperlman. By way of background, I'm the Dean and a Professor of Law at Suffolk University Law School, where I've written for many years on regulatory reform in the area of legal services delivery. Also relevant to my testimony today, I previously served as the Chief Reporter for the ABA Commission on Ethics 2020, the Vice Chair for the ABA Commission on the Future of Legal Services, and the inaugural Chair of the ABA Center for Innovation. I mentioned those experiences just by way of background because they inform my testimony today, but I should emphasize that I am here testifying strictly in my personal capacity. I have a couple of general comments, and then I want to make one specific comment in the context of Recommendation 1.0. In general, I strongly endorse your efforts and believe you are taking critical and necessary steps to improve access to legal services, not only in California, but I also believe through your example, the nation. You already have heard through online comments and will continue to hear strong objections to your work, suggesting that if your recommendations are adopted, the sky will fall. When you hear these objections, I strongly encourage you to ask for evidence that these harms will actually occur. And if you do, you will find more speculation than evidence. And that's because, in reality, many countries around the world have already adopted precisely the sorts of recommendations that you are proposing. And the sky has not fallen. There is no evidence that the public is at any greater risk from new forms of legal services delivery than traditional arrangements for legal services delivery by lawyers. You should also ask your objectors what their proposed solutions are to the access to justice crisis that we face in this country. Ralph Baxter just alluded to them. And what you will hear are three traditional solutions. People will suggest we just need more pro bono work. We need increased funding for civil legal aid. Or we need civil Gideon rights. These are all terrific strategies, important strategies. But we all know they have been tried for decades, and we are no better off today than we were 30 years ago. To the contrary, the situation is growing more dire. We need new strategies. We need to unlock new forms of legal services delivery, both by lawyers and other kinds of legal professionals, if we hope to address the problems that exist. And your recommendations, I believe, are critical to that end. With those general remarks, I want to pass along a comment with regard to Recommendation 1.0, where you have concluded that it is unnecessary to redefine the practice of law in California. I understand very much the reason for this choice, but the current definition in California is highly ambiguous and difficult to interpret, especially in a rapidly changing world. The problem is this: an ambiguous definition has a substantial chilling effect on potential innovators. There is a way, in my view, to eliminate this ambiguity and spur innovation while still protecting the public. In particular, I encourage you to examine the approach in the UK to the unauthorized practice of law. Rather than trying to define the practice of law in some ambiguous and overbroad way, as is currently the case in California and throughout the United States, the UK says that anyone can practice law-related activities unless those activities are specifically reserved for authorized professionals. That is, the burden is on the profession to identify specific areas of legal services that only legal professionals should be permitted to perform. But everything else is available to be offered by others, and the UK identifies 6 different reserved areas. No doubt, this approach to the unauthorized practice of law has potential problems and risks. I noted in your report that you identified the possible risks here, which is that the delivery of some kinds of services will take place without adequate oversight. In the event such problems arise, however, there is a solution. You can simply add new reserved activities to the list of otherwise reserved activities, or add additional regulations about who can provide those services and how they should be delivered. In short, I think the U.S. has a great deal to learn from the UK, not only in the area of alternative business structures, which is one of your
core recommendations, but in this other area as well relating to the unauthorized practice of law. I will close with this thought, which is citing the World Justice Project, which looked at 126 countries around the world and ranked them in order of their ability to provide affordable legal assistance to those in need. The United States ranked 99th out of those 126 countries. We have a very serious problem. The traditional solutions are simply not working. We need new ideas, and regulatory reform is a key to unlocking them. Those regulatory reforms need to include not only to the changes to the law of lawyering, that is the rules of professional conduct and rules like Rule 5.4, but a much more ambitious effort to look at the law of legal services more generally in some of the ways that you are already doing, but I also believe in ways that you are not, for example, in the area of the unauthorized practice of law. I applaud your efforts, and I appreciate your time. Thank you very much.
Thank you so much.
Hi, my name is Richard Lubetsky, L-U-B-E-T-Z-K-Y. I'm a member of the California Bar. I also serve as general counsel to the California Association of Legal Document Assistants, known as CALDA.
Known as what?
CALDA, C-A-L-D-A is the acronym. And legal document assistants, as most of you are probably aware, are a creature of Business and Professions Code 6400. Which allows non-attorneys to provide certain services that do not include the giving of legal advice. Specifically, legal document assistants can help pro per self-represented litigants prepare legal documents using the information that is provided to them by the consumer and to help assist in filing those documents. They can also provide general published forms. They can provide general information that address various legal topics. Many of you may not know that this has actually turned out to be quite an interesting development, because over the years that the statute has been in place, most or many of legal document assistants have forged working relationships with attorneys, so that when their customers do have a legal question that they're unable to answer, they can send them to an attorney, often at a low-cost prearranged consultation, to have their legal issue addressed, and then they can come back to the preparer, tell them what the attorney said needed to be done. Preparer can then assist them in the preparation of the documents. That's turned out to be a very effective relationship, although many more attorneys would probably like to be a part of that, but are afraid of doing it because they are concerned of state bar investigations for aiding and abetting the unauthorized practice of law, or being accused of improper fee splitting. So one of the things that can be done to help consumers is to increase or foster the growth of the relationships between LDAs and attorneys, to try to enhance those working relationships and to try to create an atmosphere where attorneys are more at ease of not being afraid to work with legal document assistants for fear of running afoul of the problem with the state bar. And the other major component is that most consumers who come in are pretty sophisticated. They've done research on their own. They've gone to know those self-help books. They've done research in the library. But one of the big things that LDAs do is help direct people to where they can find information that they can access to help educate themselves, to become better informed consumers, and to learn what the process is they need to do, the processes they need to work through, the forms they need to utilize to accomplish what they're doing, by referring them to the Judicial Council self-help website, which has a wealth of information, individual court websites. Many attorneys have informational blogs on their websites, all sorts of resources. Also, under 6400, legal document assistants can distribute any general published information that's been written or approved by an attorney. So, for instance, if a legal document assistant is trying to help someone in a divorce case, and the same legal issues or questions come up over and over again, the information that a legal document assistant may not directly be able to communicate to the customer, they may have a handout that was prepared by an attorney that discusses the frequent common areas that these consumers are going to be confronted with when dealing with their legal situation. So we feel that this has been a service that's really helped a lot of low and middle class income people to handle their own legal matters, and that is a component that we don't see addressed listed in any of your options for increasing legal access that we feel might have been overlooked and greater attention should be paid to as far as trying to increase the working relationships between LDAs and attorneys. The other comment concerning defining the practice of law, we would agree that it's not a good idea to try to redefine it. Defining it is already kind of a problem. We have some case law that defines what the practice of law is in certain types of situations. You have case law that says drafting contracts, other case law that says if you have to apply reasoning to a particular fact situation and apply and interpret the law, that's a practice of law. But the better approach is probably what the legislature has kind of done by carving out exceptions that clearly state what the practice of law is not. So, for instance, in 6400, you have a list of things that legal document assistants can do which are not the practice of law. And in fact, 6400 codifies the People versus Landlords Professionals case, which is the seminal appellate court case which says that it is not the practice of law for a non-attorney to hand out general legal information that is generic, so long as they don't attempt to interpret it and tailor it to an individual's particular factual situation. And that was the basis for the legislature having the authority to enact 6400, and the statute in the legislative history specifically references that case. For instance, the issue of whether or not a non-attorney, if they use a software program to prepare a legal document, is that the practice of law? Well, there's actually a bankruptcy law case out there that says that if you're using a software program where you input the information, that program will automatically repopulate the boxes with the same information wherever it belongs elsewhere in the form, that is the practice of law, because you're not the preparer is not manually transferring the information from the intake form and putting it into the field on the software program. The computer program is doing it automatically, and the court came to the conclusion that, in this case, LegalZoom was preparing bankruptcy petitions that way, and they said, well, the person on the other side of the computer screen is running this program, and it's an automatic program which automatically populates the information. That's a practice of law, and they banned LegalZoom nationwide from preparing bankruptcy petitions, and we feel that's kind of a ridiculous outcome. I mean, a software program is no different than helping someone fill out a judicial counsel form. It's all you're doing is taking the information that's being provided to you and putting it in the blanks on the forms of the boxes on the program. So things like that to clarify what is not the practice of law would also help facilitate the ability of non-attorneys to make technology and other systems available to the public without fear that by doing so, they're going to be accused of practicing law without a license. So we would just urge that this committee give some attention to Section 6400 and look at ways that perhaps that can be greater utilized to enhance the cooperation between non-attorneys and attorneys to help better provide services to the public.
Thank you very much.
Good afternoon, everyone. My name is Dora, D-O-R-A. Last name is Dye, D-Y-E. I am a professor at the paralegal program at City College of San Francisco. I'm also the director of that program. I am here today not only to speak about my program, but on behalf of many paralegal program directors throughout the state of California. We met and I was voted to come here today to speak to you about this matter. So we are not here to support or oppose what you're proposing. In fact, we are very much in favor of finally that you are thinking of providing access to justice to people who do not have such means. But we have no comment at this time on what you're proposing under 2.1, 2.2. We're waiting to see how that plays out. We are here primarily to inform you that we are paralegal program directors. We provide education to train so-called non-lawyers, not necessarily to work on their own, but to work in conjunction with lawyers in law firms and corporations. We've done that for many, many years. But we are here to offer to you and remind you that we exist as an educational component. Whatever scheme you come up with, you will need to train people to take on this role. They will need training. They will need continuing education. We have been doing that for decades. We have programs. We have faculty that consist of lawyers, paralegals, judges. We have the facilities. We have the technology. And there's been a lot of concern about the technology here. And every course that we design using technology, we test. We have a person on our campus who goes through to figure out whether this is accessible to somebody with a disability and how to make that course accessible, whether it's putting in subtitles, whether it's putting in sound so that somebody who can't see can hear, and other features. We have classrooms that accommodate people with disabilities, and we have the facilities to offer these courses. And so we are here to offer those services for your consideration. The other thing is that we are affordable. So some of the schemes that already exist, like in Washington, they cost a lot of money. And I work for a community college. San Francisco's City College is free to people who live in the city. And the other schools throughout the state, the tuition varies from $46 a unit to $200 or $300 a unit. That is a far cry. So if this is to be access to justice, it should be access to the education of those who are going to provide the services as well. And that's all I have to say. Thank you.
Thank you very much.
Good afternoon. I own a company called the Ticket Clinic. It's a consumer firm. We handle traffic-related matters. And my main concern with this proposed change is very simple. Over the years, we've handled hundreds of thousands of cases over the past 35 years. And the biggest issue that I want to explain to this board is the tens of thousands of times we've had clients come to us because they've been to an entity who had marketed, in our case, traffic-related matters. They had ended up in the hands of a professional or quasi-professional who did not have the expertise, and we had to fix the problem. I'm going back to what I believe the first speaker had said regarding some sort of teeth in the regulation for the non-lawyers. Every attorney that has worked for us realizes that as a law firm, we take care of our clients first and foremost. Some of the companies that market in my field I've spoken to, and they consider these individuals not clients but customers. There's a profit motive. Some of the new apps that are out there that I believe the board has looked at and is familiar with are solely interested in the profit motive. They are not attorneys who have taken ethics courses, passed bar exams, and are concerned with their clients first, and of course the financial aspect at some point in the calculus. These are companies that are profit driven, and unless we have some sort of regulation in that entity, which is basically the marketing aspect of this, I applaud the other technological advances that will help all of the citizens of this state. But the marketing to the citizenry by non-lawyers is the thing I take issue to, unless there's some sort of way that we can, make sure that they don't harm the public. I know that not harming the public is one of the two things that you're most concerned with, and I applaud that. But how are we going to keep these non-legal entities from doing just that? What are we going to do? And I don't really see that at this juncture. What are we going to do to assure that, just as a lawyer with a bar card who has to have all of the rules of the Florida bar and follow them, how are we going to do that with non-lawyers? And that's the question I ask, and it's solely involved with what we've seen. I mean, everybody has heard stories from either yourself or a colleague or a family member about, do you have a contractor? Because my contractor just ruined my bathroom, and I need another contractor. And that's what we have seen time and time again in my practice, with people going to entities that are not lawyers, ending up with terrible results, and we have to go in and fix it. And in many cases, it has harmed their lives. So it's just something that I wish this board would look into a little bit closer. I appreciate your time.
Thank you so much.
Hello, my name is Zach DeMiola, Z-A-C-K-D-E, capital M-E-O-L-A. I'm a lawyer. I'm a member of the California Bar, and I am a manager at ILES, the Institute for the Advancement of the American Legal System. So ILES is an independent think tank at the University of Denver committed to improving the civil justice system. This task force cited to the ILES Independent Regulator of Legal Services policy outline in its circulation for public comment, written by Jillian Hatfield and Lucy Ricca, which is an example of the sort of work that we're trying to do in this area right now. In fact, we are a research entity that works with stakeholders and experts to develop practical solutions to tough problems. And one of the problems that deeply concerns us is that the legal profession is not serving the needs of the vast majority of people with legal problems. In 2015, the National Center for State Courts found that 76% of all cases in state court have at least one party that is self-represented. In family cases, that number increases upwards to 80 or 90%. And often both parties lack assistance of an attorney. The problem reaches far up the income scale. It's not only the poorest who lack access to legal services, it's also the middle class and even small businesses. And people are encountering a legal system, consequently, that they are perceiving as being unfair and out of touch. And they want and they need help. In 2016, ILES conducted its Cases Without Counsel study, where we focused on the experiences of self-represented litigants in family court. And more than 85% of the people that we spoke to in that study wanted advice and representation, but they couldn't get the help they needed because the cost was too high for them, and they were unclear on where to find the right resources otherwise. One participant told us, and I'm quoting, "It felt very much like wandering through a room with no lights on, and you'd bump into something. You'd ask somebody about it, and they'd shine a little flashlight and say, go that way. But nobody ever turned the lights on in the whole room to give us an idea of exactly what it should look like. Well, service providers are trying to help people with their legal problems. But under current rules, and with limited exception, anyone other than a lawyer providing legal services would be engaging in the unauthorized practice of law, which means they can be subject to sanction even if those services were actually helping and not harming consumers. And current rules prohibit lawyers from sharing fees with others, so people with novel and potentially groundbreaking solutions cannot partner directly with lawyers to develop new legal services. Innovators who would otherwise focus on how to meet consumer needs are spending dollars and energy trying to maneuver around being seen as offering legal services in the first place, or they're just avoiding the market altogether. One such entity recently told Isles, "It's expensive to operate in the gray. It severely cramps our capacity to innovate and serve the market." So, without change, access to justice is in danger of becoming just a catchphrase that doesn't have much relevance to most Americans. And that's why Isles applauds the effort of this task force. Isles understands that the recommendations that have been circulated for public comment are probably a little more conceptual than concrete in terms of rulemaking. But even so, specifically, the ideas embodied in recommendations 1.1, 1.3, 2.0, 2.1, 2.2, and 3.2 are the ideas that should be pursued. And Isles believes those are the sort of thoughts that are the critical first step to making legal services affordable and accessible to the people who need them the most. Thank you.
Thank you very much.
Hello, Linda Kilb, Linda Kilb. Thank you very much for the opportunity to address you today. I'm an attorney with the Disability Rights Education and Defense Fund and a member of the California Bar for over 30 years. I offer today's comments on behalf of a coalition of offices that have, for many years, received funding as part of the formal California legal services system. These offices are either solely or significantly devoted to advancing and protecting the civil rights of people with disabilities. We have deep ties to the California disability community and recognized expertise in both federal and California disability civil rights laws. To date, we have submitted 7 public comments to the California courts, the Judicial Council, and the State Bar, addressing issues of technology access for people with disabilities. These comments speak to access within the California legal profession as well as the California state court system. The first of these comments was submitted in January of 2013. The most recent was submitted in January of 2019. These submissions have provided extensive detail on disability access barriers and disability rights law mandates. They have also offered insights into the types of resources and expertise that are necessary to comply with these mandates. Given this history, we are extremely disappointed that the word disability does not appear even once in the 251-page report this task force issued or its attachments. There is no reference to the need to comply with disability-related legal mandates and to avoid disability-related barriers. There is no indication that the task force members have legal or practical disability-related expertise. There is no indication that the task force has reached out to anyone with such expertise. And there is no indication that the technology-related platforms referenced in the reports have been vetted for compliance with the long-standing web content accessibility guidelines. Our Disability Rights Coalition also plans to offer written comment on technology access issues relevant to the work of this task force. But given the continued absence of attention to these issues, we take this in-person opportunity to underscore our concerns. We again urge the State Bar, the Judicial Council, and the California court system to proactively institutionalize protocols to ensure that these issues will be effectively addressed going forward. More specifically, we reiterate the concerns that we've been raising for years now. Significant and sustained expertise and resources will be needed to address these concerns, which I summarize as follows. First, there is a need for explicit references to disability rights and disability access. Second, stakeholder participation alone is insufficient to address disability access. Third, innovation and experimentation must not compromise fundamental disability access mandates. Fourth, budgetary concerns must not drive migration to inaccessible technologies. And fifth, widely available technologies and user practices must be independently evaluated for disability access. Finally, given this forum and format, we have limited this testimony to issues uniquely within our disability rights expertise. However, the absence of disability references in the report causes us to wonder if other types of relevant expertise are also missing. Additionally, we urge careful attention to the more general concerns of the California legal services community of which we are a part. We are grateful for the public comment period that is intended to give the task force the benefit of such wider input. Thank you for your time and attention.
Thank you very much.
My name is Art, A-R-T, Lachman, L-A-C-H-M-A-N. I'm a practitioner in Seattle, Washington. I'm a former president of APRIL, the Association of Professional Responsibility Lawyers. During my term as president, I appointed another former president, Mark Tuft, who's a member of this task force, as chair of the APRIL Advertising Committee that proposed reforms to the advertising and solicitation rules that I know this task force is also considering. I am speaking today on behalf of the APRIL Future of Lawyering Committee, of which I co-chair, which is looking at issues regarding the delivery of legal services in light of changes in technology, the need to innovate in the provision of legal services, to improve availability of affordable legal help to consumers. APRIL is a broad-based association of lawyers who represent clients in all aspects of the law of lawyering, including advice on legal ethics and risk management, defending lawyers in disciplinary proceedings. We have academics, lawyers who work in-house as ethics and risk management advisors in law firms, and even folks who serve as ethics counsel in bar associations and work on bar ethics committees. Our committee also has a broad-based membership. In addition to APRIL members, we also have non-member regulator types, academics, people involved in related efforts around the country and around the world, including in the UK, Australia, and Canada. We also have liaisons from organizations such as the ABA, Center for Professional Responsibility, the National Organization of Bar Counsel, Conference of Chief Justices, the FTC, the Institute for the Advancement of the American Legal System, ILES, as Zach previously spoke, Legal Marketing Association, and the Association of Corporate Counsel. The APRIL Committee's work is preliminary, and we're in the process of working through the issues your task force is also looking into. Anything our committee comes up with will have to be approved by the APRIL board. Having said that, we do applaud the California effort for bringing these issues to the fore and recognizing that reform is needed now to fill the wide gap in the consumer need for legal services. We're really looking forward to seeing these concepts more fully developed. We are especially like from your current memo, including non-lawyers in the process, which is crucial, recognizing the importance of innovation and the role of technology in our world, recognizing the need to develop data in implementing regulatory reform, very, very important. Recognizing that defining the practice of law with exceptions is pretty much a useless exercise that doesn't advance the effort in any meaningful way, and considering both the APRIL proposal and more modest ABA proposal on the advertising and solicitation rules. Because the ATIL's options concept memo is, like our effort, also preliminary, and most of the recommendations are pretty general in nature, I thought I'd share with the task force some general thoughts and suggestions based on our experience so far with the APRIL effort looking at these issues. the first point I wanted to make is that I don't think you should rule out working with other jurisdictions and learning from what they're doing on these issues. The April Futures Committee is looking at the entire universe of what's out there, including recent reform efforts that are underway in Arizona, Utah, and other places on a whole variety of issues that relate to what we're talking about. We're gathering resources, we're evaluating very difficult issues that relate to the delivery of affordable legal services, and trying to think out of the box on what will work best for both consumers and lawyers while still protecting the public. April can facilitate helping to get to a set of rules and regulatory approaches that interested states can work with. It would seem that an effort to achieve some aspect of uniformity would be worthwhile in this effort. We think it would help convince the practicing bar, judges, and the public that such reforms will have the potential to improve access to affordable legal services and also improve the ability of lawyers to provide these services in the marketplace. Second, the April Futures Committee leans to coming up with a broad set of recommendations that touch on all related issues of legal services delivery. Thus, while technology is an important aspect of these issues and appears to be an emphasis in the ATIL's options memorandum, it's also important to include issues relating to non-lawyer people performing legal services. Also, there are other issues that relate to legal services delivery. I point to since we're ethics nerds in April, to the list of 5 rules in the RPCs that impact the same issues. Our committee is evaluating those at the same time. And those include, for example, Rule 5.5, which deals with cross-border practice, as well as fee sharing and referral fee issues, both in Rule 7.2 and in 1.5. In conceptualizing and thinking through changes, the rules and the policies that underlie them often overlap, and we need to think through these changes and their impacts. This doesn't mean that everything will be implemented at once, but from my experience in doing this with April and in my own state of Washington, it's a good idea to see where we want to end up to make sure we're thinking all the issues through. When thinking about ethics rule changes such as Rule 5.4, our committee has found it helpful to anchor evaluation of the rules to a set of regulatory objectives, which I didn't see in the report. Professor Laurel Terry at Penn State has been involved in these issues for years, is working with us, and she's gathered information that we're finding useful when we're looking at the rules to have some kind of anchor to what we're talking about with the rules, and are they really achieving the objectives, and suggesting that in some cases they just don't do that. We can also help in those kinds of issues with your task force. The last point I want to make is that the April subcommittee thinks it's very important that a large part of these reform efforts, is changing the way all of us think about these issues in a very different world from when the rules were created in the first place. We're not just talking about access to courts. We're talking about something much broader than that. We're talking about access to affordable legal services by consumers of at all levels of the income spectrum. In my experience in advising lawyers in these areas, and I get calls as a person who represents lawyers, many of these rules simply have a chilling effect on undertaking efforts that would aid consumers. For example, in holistic practice and multidisciplinary practice. And as shown in Professor Henderson's report, restrictions on non-lawyer investment tend to discourage innovation. It may well be worth trying to reverse some of our presumptions that we've adopted, that activities that might actually benefit consumers are presumptively prohibited. Change those presumptions, change the way we think about them. And regulate reasonably where regulation is needed based on the risk of harms to consumers. There's a long way to go on this project here in California and with April, and obviously the devil is in the details. We're looking forward to seeing the more specific proposals as this effort moves forward that come from this task force. April is here to help in any way you see fit and find useful. Thank you for this opportunity to speak with you today.
Thank you very much.
Stephen, Stephen, Gillers, Gillers. By way of introduction, I have been since 1978 on the faculty of NYU Law School, where I teach a course on lawyer regulation. I have a case book now in its 11th edition on lawyer regulation, on the rules governing the profession. I was on the 2020 Commission with Andy Perlman. I was on the ABA Multi-Jurisdictional Practice Commission before that. It's a subject that has long interested me. That is the industry itself, not only the bilateral obligations of lawyers to clients, but also how we construct the purchase and sale of legal advice. I'll try not to duplicate much of what you've heard, but I do want to stress a few points. You've heard that there is a great need, and this is certainly true. The numbers vary depending upon who you read, and I think they vary because it also depends on the nature of the need that a potential client has and the income of the potential client, so that some needs are totally unmet and some may be met with great sacrifice. Let's say the range of unmet needs is between 50 and 80%. Think about that. We live in a society that prides itself on the rule of law. We live under the rule of law. But if you can't get legal advice, whether it be in connection with a court matter or a negotiation or some transaction, in a civil case, certainly, you don't live under the rule of law. I mean, the rule of law depends on knowledge of the law as it pertains to your problem. And if you cannot get that, then much of what the rule of law promises, you are denied. Now, Rule 5.4, which we're talking about, along with other rules, offers in its comment an explanation for the categorical, absolute prohibition on non-lawyer interest in the delivery of legal services for profit. For profit. For profit because in the 60s and 70s, bar associations attempted to shut down public interest law operations using the specter of the dishonorable layperson as the wedge to prevent the kinds of cases that those organizations brought. They lost. The Supreme Court rejected that, and that opportunity has not rearisen. So look at the assumptions that the prohibition makes. They're quite remarkable. The comment simply says that the rule is there to protect the independent judgment of the lawyer. That's it. That's the only explanation. Now, think about the assumptions that go behind that explanation, whether they pertain to the definition of unauthorized practice or to whether or not non-lawyers shall have financial interests in for-profit law firms. Assumption one in both instances is that the non-lawyer will sacrifice his or her client for money. They can't be trusted not to do that. And there are enough of them who will do that such that we need a categorical prohibition. Not a nuanced rule, but a categorical prohibition to protect the party who might otherwise benefit from access to the non-lawyer advice. That's the first assumption. The second assumption, equally remarkable, is that if a non-lawyer is part of a law firm, he or she will not only try to betray a client for money, but will work his or her will on the lawyers to get them to betray the client for money. That the lawyers will succumb to these entreaties. So the non-lawyer in the law firm and the lawyer in the law firm will, in this manner, because the non-lawyer is there, violate duties to the client. Now, these are not credible assumptions. For one thing, we allow non-lawyers to occupy positions of great power and influence in our society. Presidents of universities, CEOs of Fortune 500 companies, presidents of charities, where we trust to their compliance with their fiduciary duties. This is not to say there are not rogue non-lawyers, just as there are rogue lawyers. It's a question of balance. We don't say that non-lawyers are trustworthy in all of these other positions, but they are not trustworthy when it comes to legal representation without uncovering an assumption that cannot be defended. Now, one would assume that if that was our purpose, if we really believed that it is simply too dangerous to allow non-lawyers into this aspect of public life, not others, but this aspect of public life, then, and notwithstanding the benefits that might ensue if we created rules, I'll say more about that in a second, inviting them to participate in the delivery of legal services, then one would expect that the profession would support that conclusion with some empirical justification, would look to nations that have allowed non-lawyers to be part of for-profit law offices or have narrowed their definition of unauthorized practice of law. Look to Washington, D.C., where since 1991, non-lawyers have been allowed to be part of for-profit law firms, would empirically defend, given the cost, that assumption, not simply write a comment saying, in order to protect the independent professional judgment of lawyers without further explanation. I don't think that empirical investigation would be fruitful on the side of the ban. I think that it would turn out to show us that there are things we can do to have the best of both possible worlds, and this is where I want to turn next. The solution is regulation, just as lawyers are regulated. We're not talking about opening the door to anyone to come in and do what lawyers do now, no matter what it is. The solution is serious regulation, codes of ethics, controlling who can do it, some kind of licensure, so that we can ensure that the people who qualify to perform a defined set of services are capable of doing so. The solution is some regulator who oversees them just as a regulator oversees lawyers. It doesn't have to be all or nothing. Now, most of your recommendations, as I read them, are at a certain level of generality about what we might strive for, what we might consider. The proposals in 2.0 and ETSEC are of that kind. The one that is not, and the one I want to address finally, is the one that would allow non-lawyers to have financial interests in law offices that operate for profit. This is your alternative one, which, by the way, is heavily reliant, I'm pleased to say, on what we did at Ethics 2020. We drafted something nearly identical in Ethics 2020, but there was fear of presenting that to the House of Delegates because it would be shot down. Probably it would be shot down, but that's not a reason for not presenting it. It should be presented so we can have the conversation, and the great thing that you've done now, beginning now, is creating the space for the conversation. We didn't do that. Regrettably, we didn't do that. You have taken our work, which otherwise would have gone into the archives, and you have resuscitated it, and I appreciate that. I would make two suggestions, because the credibility of whatever you do, and you have a lot to do, I don't envy what you have a lot to do between now and the end of the year, is going to depend upon the level of confidence the proposed regulation gives the public and the bar. In the amendments to Rule 5.4 that you have proposed, I would add one and possibly two things. First of all, I don't think it's good enough to ask the non-lawyer to sign a document saying he or she has read and agrees to comply with the ethics rules and the rules governing the profession. Lots of people will sign that, though it won't be true. Lots of lawyers, when they're sworn in, say they've read the state's rules of professional conduct when they have not. So I think what they need beyond that, what you need beyond that, is a mandated half-day class, a full-day class, on the rules of professional conduct and other rules governing the legal profession. They should have to sit down and listen to a lecturer and ask questions and participate in the conversation about what these rules are and why they are there, what the values they protect are. I think that's very important. And then, just as lawyers must, they should have to take a CLE every year of 2 or 3 hours on legal ethics, just as lawyers do. Why exempt them from that requirement? Bring the new licensed person as close as possible to the structure of lawyer regulation. The other thing you might consider, and I'm not as sure about this, but I think it's worth discussing, is whether and how the person who purports to become financially interested in a for-profit law firm should have to undergo some kind of character review, just as lawyers do. Why not? It's expensive, perhaps, but I think they can be expected to fund it. The closer you come to the lawyer model, the easier it will be to persuade people to accept it. Now, as I say, many of your other proposals are at a higher level of generality and need detail, and maybe that detail comes after you disband through another entity. Finally, I think the alternative two, just to get granular for a second, is not advisable. It's too much too soon. This is the one that would allow lawyers and non-lawyers with informed client consent in writing to divide what would otherwise be a legal fee. I think that goes too far right now. Despite my exuberance, which I can hardly contain for the work that you are called upon to do, I urge you to be cautious, to go slow, but to go slow, because we're in a brand new world, and although I believe that the train has left the station on the effort to change the regulation, and that 50 years from now we'll look back on this time and say that's when it began, it's going to gather speed only if initially it inches along, and that's what I would encourage you to recognize. Thank you.
Thank you very much.
It's Tom Gordon, T-O-M-G-O-R-D-O-N. I'm the Executive Director of Responsive Law. We're a national nonprofit organization working to advance policies that provide people with greater access and affordability in getting legal help. I want to thank the task force for doing what we think is overall a wonderful job of balancing the potential for increased access to legal help with the potential for consumer harm. The task force, I think, has looked at regulation as something that needs to address specific potential harms rather than taking regulations that were created perhaps to address some of those harms but have now taken on a life of their own. And I think it's important to look at the principles behind the existing rules of professional conduct rather than take those rules themselves as gospel, but going back to first principles, and I believe that's what the task force has done. We'll be submitting some much fuller written comments, and I don't want to take the whole rest of the task force's time today and deprive everybody else of the opportunity to testify, but I did want to hit a few of our top-line thoughts on the report to date. First of all, on the proposals regarding what to do with Rule 5.4, I was listening to Professor Gillers a moment ago and agreeing with everything he said, and was actually a little surprised then to find him urging you to exercise caution in moving towards option 2 of the 2 ways to address 5.4. I think it's very important to have the courage of your convictions in this, and if this task force that has studied these issues for nearly the past year, and if they believe that this is truly the way that the profession needs to go and that regulation needs to go, then they should advance that and let the debate happen. It's our belief at Responsive Law that you need to get legal services to be affordable, you need a true mass market consumer law firm, which just doesn't exist today. Your largest consumer-facing law firms are 10 or 12 attorneys at max. That's not a scale at which services are going to be affordable to anybody. That doesn't mean that these changes will happen immediately once ABS is allowed. You look at any other area where regulations may have changed. The change didn't take place immediately. The UK is moving along, but the regulation has only taken place. Regulatory change only took place about a decade ago, and they're still trying to figure out what's going to work in the market. So ABS is a necessary but not sufficient condition for improving access to legal help. There also needs to be change within the culture of the profession, and that's a huge obstacle, one that's probably beyond the mission of this task force. You've got a lot to do already. But one thing in thinking about the concerns about independent professional judgment for lawyers, a few years ago, my wife and I traveled to Chicago for my law school reunion, and in order to attend, we brought our then 18-month-old daughter with us, and we didn't want to take her to the reunion. We didn't think any of us would have a good time if that happened. So we went online, went to Urban Sitter, and found a babysitter, because we didn't have any good leads on babysitters in Chicago otherwise. We left our daughter with the babysitter, who I'm certain shared some of her fees with Urban Sitter. Urban Sitter was able to get this service to us because they were funded by lots of venture capital. And we didn't for a moment worry that this babysitter might be putting the needs and demands of Urban Sitter ahead of the well-being of our daughter. Now, babysitters don't have a code of professional conduct they need to follow, but we still didn't have this concern. So it boggles my mind to think that we have a concern that lawyers, with their own independent requirements to put clients first, would somehow be swayed in a way that a babysitter wouldn't be, to put some other financial need ahead of the needs of their client. A couple of other points on some of the proposals. One of the things that we thought was noteworthy was the idea of a safe harbor for innovators in legal tech against unauthorized practice of law restrictions. And that's something that I think is very good in theory, and it's important to allow that innovation to take place. Our concern is we wouldn't want such a safe harbor to then morph into a standard, we worry that someone would be brought before a UPL commission who is engaging in something that may be protected First Amendment activity of distributing legal information, or doing something that is purely done through code without any independent personal service involved that would be protected under the First Amendment, and then be asked, well, you could have just gone in the safe harbor. Why didn't you do that? Well, they didn't have a need to. It was something that is already allowable activity. And so we wouldn't want to see a repeat of what happened to Norman Dacey 50 years ago when he engaged in what was First Amendment activity in publishing How to Avoid Probate, but because it was considered to be somehow related to legal services, it then became something that lawyers thought would fall under UPL restrictions. Another substantive point is that the task force has suggested replacing California's advertising rules or making them conform to the recent ABA changes. And we would advise going a step forward and streamlining those rules to essentially get to a prohibition on false and misleading statements. And to paraphrase a wise lawyer from 2,000 years ago, false and misleading is the thing is the main principle we should be concerned about. Everything else is commentary. Finally, I want to address the elephant in the room, which is that may not be such the elephant in the room. I know you've gotten hundreds of comments from people who are disgruntled about various things, but my hunch is that a large proportion of those are people who are concerned about losing their place in the new legal economy. There's a few things that I would say to you and to them. One is that lawyers bring a lot of skills to the table beyond just having a license to do what other people can't. If we were factory workers or farmers, we'd be in a lot of trouble, as many are in a changing economy. But as the economy evolves, lawyers bring a lot to the table. If they aren't able to adapt to a new economy, then they probably had to do they should have been doing some better skill development along the way. Second, this actually opens, a lot of these changes open up a lot of opportunity for lawyers. One group that doesn't exist, but I wish did, would be the baristas. There's a lot of folks out there who graduated from law school and are having a lot of trouble finding a regular legal employment or even any legal employment and are working at Starbucks. And if you ask those folks, hey, would you like to get a job working for a large mass market consumer legal firm where you could work a 40 to 50 hour week practicing law, not chasing billables, and just work at the top of your license and make, say, $70K a year? I think they'd almost unanimously take you up on that. In fact, I think a lot of large firm associates might also take you up on that offer. Finally, above all, regardless of those concerns, the duty of the State Bar is to protect the public. And that's what these revised regulations do. So lawyers' economic well-being, while I think is not as big of an issue as some lawyers make it out to be, is not, frankly, the concern of the State Bar or of this task force. And so I encourage you to continue putting consumers first and making reasonable regulations for the public. Thank you.
Thank you very much.
Nick Rishwain, N-I-C-K-R-I-S-H-W-A-I-N, is Nicholas. Boy, I just cleared out the room. That's not uncommon, but I want to, there's been some great comments here, great commentary here today. Andrew Perlman had some great comments. Zach Demiola had some great comments, and thank you for our friend from the Berkeley Accelerator. There are certainly a lot of things that did not get covered in this type of an issue, in this type of a setting. I don't want to talk about those today. What I wanted to come and do is give you guys just sort of a round of applause. This is hard work that you've done, and you've gotten a lot of comments. I've seen some commentary from my friends on Twitter who are a part of this. There's been some hugely disparaging comments. I read some of those comments yesterday and the day before that have been submitted. Most of those are based on fear, fear of the future, fear of the unknown, that type of thing. And I didn't want you guys to, your hard work on this task force to go unnoticed. For those of us who aren't participating actively, I wanted you to know you have the support of many of us. It's never going to be perfect. There are going to be concerns from a lot of people in the public. There's going to be concerns from special interests and other stakeholders. But it's very much appreciated, the hard work that you've done here, and I thank you. And I hope that you don't let those public comments drag you down too much, all right? Thanks. Bye-bye.
Thank you so much.
My name is William McKinnon, W-I-L-L-I-A-M, M-C-K-I-N-N-O-N. I am a 32-year litigator, and I am not a professor at a university, and I don't have a national organization. I'm here representing an indigent woman in Los Angeles. She had an apartment. She was a tenant in good standing. Water pipe broke. Property flooded. And her landlord wanted her to move out. She had a good tenancy. She liked her apartment. She wanted to stay there. I don't practice tenant law. I spent the first 20 years of my practice defending our economic system against unlawful intrusion by foreign actors. And having completed that successfully, I decided to move on to protecting our environment in California. I've assembled a team of 15 scientists, data miners, and others, and we conduct our business in full compliance with the law. However, it has been my practice when people come along to me and say, I have a problem, to offer my services pro bono. I think we have a duty to do that. So, this person didn't come to me for tenant advice, thank goodness, because I would have rejected her. She went to someone else. She went to a nonprofit organization that we will call Tenants Legal. Tenants Legal has offices. They have young attorneys willing to work for wages, assumably. Most of them have not been practicing long enough yet to smell danger. Sort of terrifies me to see people that innocent. And they got her in. They had her inquired, and they found out that she had 3 insurance companies, all of whom potentially had liability for the damages. So guess what? They could represent her. They took a $5,000 retainer. At the time, they told her that it was for costs. Subsequently, they have said it is a true retainer, which for those of you who do not practice law, is the fee that you pay to have a particularly prestigious lawyer available at your beck and call when the police arrest you. You don't do it when you have an unlawful detainer in your hand. But they took her money and they had her sign the last page of a contract, but they didn't actually give her the first 6 pages of the contract until I got involved 6 months later. So she signed a contract, gave the retainer, didn't know what the contract was, but it said legal firm on the door, so she believed that she was protected by the things that I've always thought would cause me to lose my license if I violated the rules of ethics and the law. So they took her retainer, they didn't put it in a trust account, they didn't tell her about potential offers of settlement, they didn't tell her about a demand for mediation contractually provided, which had as a penalty, if she refused it, her obligation to pay opposing parties legal fees. A summary judgment motion was brought. They offered no evidence in opposition, although they'd asked her to get experts, and there was an expert report available. They didn't introduce a single document, nothing. The judge said, on the record, you are wasting my time, as she granted the summary judgment. One attorney in the firm had a total of 4 years of experience and said, whoa, boy, you folks better bring a motion under 473. For those who aren't lawyers, 473 says that a lawyer can go in and throw themselves on the sword and say, oh, I made a mistake, and it's my fault, don't blame my client. The judge denied that, saying 473 is not intended for malpractice. It is not intended for negligence. It is intended for excusable mistake. Motion denied. I forgot to mention, this fellow, when he answered the summary judgment motion, used the form and ticked off the box that said that the 94-year-old landlord, female, was a convicted sex trafficker. And he answered for the woman's son, who was not present in the apartment and had nothing to do with it. He didn't tell her that there was an offer of settlement. He didn't tell her that she was about to get nailed for $65,000 in opposing parties' attorney's fees. So, this came to me not as a tenant's case, but as far as I'm concerned, as the most outrageous malpractice that I've witnessed in 32 years. And they said, Bill, help me out. So, if that was an attorney, sue him for malpractice. But it's not. It's a non-profit corporation. The contract, such as it is not with an attorney. The non-profit corporation has not qualified itself pursuant to state bar rules. So, now what have I got? Have I got practicing law without a license? Have I got malpractice? Have I got something else? I don't know. So I did what most people at my level of the profession do when we are confronted with these sort of things. I called the State Bar Ethics Hotline, who directed me to the specialist in the State Bar, who is responsible for this. And I said, you know, I've read the State Bar rules about what it says they're supposed to do, so it seems to me they're practicing law without a license. But on the other hand, I've read the Fry v. Tenderloin case in which the Supreme Court says, oh, nonprofits don't have to have a license. And then I've read the 2010 decision of the predecessor of this August group, and it said, well, we've changed the bar rules to conform to the state Supreme Court's decision. I said, fine. So I have a question. Are they practicing law without a license illegally or not? I'll get back to you when the State Bar tells me. Okay?
Thank you.
Good afternoon. Linda, L-Y-N-D-A. Last name is Shealy, S-H-E-L-Y. And I am also a past president of the Association of Professional Responsibility Lawyers, or as Art Lockman referred to us, Ethics Geeks. Sorry. And I practice law only in the states of Arizona and D.C. I'm also admitted in Pennsylvania. And I just wanted to commend you because hang in there. In Arizona, I want to just raise two issues for you to think about and give you moral support. In Arizona, we've had certified legal document preparers for a number of years. And when I drafted that rule, we were told that it would be the end of civilization as we know it. It hasn't been. It has helped consumers. But whenever you're addressing somebody other than a lawyer providing legal services, just like we have a code of ethics, there are two things you keep in mind for somebody who's affecting somebody else's legal rights. They have to be competent and they have to be accountable. You can do that if you have licensed non-lawyers providing legal services through having something like a client protection fund that they would pay into and a code of conduct. That's doable. And then the second thing I just wanted to mention is I am from Arizona. I'm not speaking on behalf of the Arizona Supreme Court Task Force on the Delivery of Legal Services, but according to the public record information that's out there, they right now are anticipating eliminating Ethics Rule 5.4 altogether. And it has been mentioned by several other folks, and I know a lot of you on the task force are familiar with this issue. 5.4 is sharing legal fees with non-lawyers or partnering with non-lawyers. Last time I checked, lawyers have backbones, and we have other rules that will regulate us. If you eliminate that rule, there are conflict rules, because really what that 5.4 is supposed to be governing to protect consumers is to make sure that nobody affects my independent professional judgment in deciding who I take as a client and how I represent them. And we have conflict rules that will do that. 5.4 is not necessary. I am one of those folks that advises a lot of law firms around the country. And you're going to hear lawyers saying this is horrible, this is terrible, because we're probably going to have to pay referral fees to our referral sources now. Guess what? They already do. They just do it really quietly. And they pretend that when you go to, I don't know, a Padres game with clients or referral sources, or you take somebody golfing, that's not paying for a referral fee. So we hate change as a profession. I commend you. Good luck with this. And actually, Arizona's already out there. We're happy to work with you. And we're already proposing eliminating 5.4 altogether. And yes, I'm sure we're going to hear it's the end of civilization. But we still have a code of ethics. And I still believe that lawyers can continue to use their independent professional judgment in representing clients, even if their partners are non-lawyers. Thank you.
Thank you very much.
Good afternoon.
We take a brief break after you're finished.
Oh, okay, sure. Hi, Jane Reardon, Jane-Reardon. Good afternoon. I'm Jane Reardon, the Executive Director of the Illinois Supreme Court Commission on Professionalism. I'm also a past chair and member of the Standing Committee on Professionalism for the ABA, and I'm currently a member of April's Future of Lawyering Task Force. I speak, however, on behalf of myself and none of the organizations that I affiliate with. I will be very brief. I want to compliment you on this hard work. It is very evident from the work product you put out that it is very well thought out. And it is also reflective, I believe, and very obvious that you sought, or the bar sought, diversity of opinion in putting on this task force not only lawyers and judges, but other stakeholders. And I urge you, I just have three suggestions for your consideration. Please seek out more folks who are not invested in the status quo during your comment period. There are so many organizations like teachers and social workers and financial planners. It actually broke my heart to hear Dora say, oh, I'm a director of paralegal programming, so-called non-lawyers. Hey, if we recognize the value of allied professionals to help in delivering legal services, this leads to my next point. Let's not separate the world into lawyers and non-lawyers. I know that's difficult because our ethics rules are replete with that binary division, but as you refine your report, you are out in front and people are looking at your work. See if you can find some other words, like stakeholders, like allied professionals, that really gives them a seat at the table. Isn't that what we're trying to accomplish here? And the last point I would like to tell you is, and other speakers have alluded to this, particularly with respect to 5.4, I often hear, but changing 5.4 would undermine the core values of our profession. And others have said this, I'm sure I can tell from your report you realize it. What undermines the core values of our profession is our failure to meet the legal needs of 50 to 80% of the population. If the ethics rules are in any way responsible, it would be irresponsible to not make some changes. So keep up the good work. Thank you so much.
Thank you very much. Okay, let's take a brief break. Lauren, how many more speakers do we have signed up to speak? Okay, why don't we take 10 minutes, come back at, it may not be quite 10, at 10 till 4, we'll get started again.
You're so helpful. That was a really great thing to do. I had totally forgotten about it.
Yeah, I mean, it's from...
It was very good. It was very good.
Okay, thank you very much. Lauren, you want to let us know who's next up, please? Thank you.
Good afternoon. My name's Fred Ury, URY, Fairfield, Connecticut. I'm the former president of the Connecticut Bar Association, former president of the National Conference of Bar Presidents, and the present chair of the Coordinating Council for CPR. So I am not here to comment about the ethical implications of the report, but what I am here to ask you to do is to write, talk to, and listen to some voluntary bar associations. I have been doing presentations about the future of the legal profession around the country for almost 14 years, since 2005. I had the pleasure of moderating a panel with Bill Henderson, Jane Reardon, and this past Thursday for the NCBP. At the end of the panel, the two questions that have been posed to me for the last 14 years from lawyers and from voluntary bar associations is, our job is to help lawyers, protect lawyers. This is the mantra I hear, right? Not consumers. And the reason you hear that is because voluntary bar associations hear from their members, if you pursue this course of changing the regulations 5.4, changing the regulations to assist consumers and help, I am going to resign from your bar association. And they do. They leave. So if you're the president of a voluntary bar association, or you're the incoming president of a bar association, there's two things that you worry about and lose sleep. One is that you're going to be the guy turning out the lights, and it's going to go out of business while you're the president, and which is not a good thing to have happen. And you think about that. Even though Bar Association has been in business for 100 years, you're still sitting there losing sleep saying, this may not do it very well. And you don't want to be the person that they say, during Fred's term as president of the Bar Association, membership went down by 750 members. So there is a tremendous hesitancy on voluntary bar, not mandatory bar associations. They don't have to worry about membership. Voluntary bar associations have to worry about membership every day. Every year we start off brand new. So when we talk about, I've probably talked to 30 state bar associations in the country. Most of them voluntary, some of them mandatory, and usually by the time I'm done with my talk and I've been talking about 5.4 and the Australian and the British, all the different things going around the world, everybody says, thank you very much for coming, and by the way, the door's right there. Have a nice time, see you later, and we're not inviting you back. Because they are fearful of their membership leaving. So, what's the solution for this? I think we have to do a really good job, a better job of educating and selling. And selling is maybe a bad word, but I'm a big believer in sales. I've spent a lot of time trying to explain that we have to change our regulatory systems. And maybe it's not just 5.4 and some of the other changes to regulations. Maybe it's also we need a lot more online dispute resolution. Maybe we need to look at that. But we need, obviously, to do something to serve this population. So I implore you, and I'm happy to contribute to that effort. We need to write. We need to educate. We need to blog. We need to inform. We need to help those voluntary bar associations around the country as they look at California and say, pox on your house, that they don't look at California and say, it's just those crazy people on the West Coast, but that they also say, no, well, wait a second, here's an article, here's some information, here's something that we can use to educate our members, because really that's what it ends up having to be. You're not going to, voluntary bar associations around the country are just not going to take the leap of faith and hope. So we're going to have to do an education. That's what I've been trying to do by going around the country for the last 10, 12 years, and it is getting some traction. There are things happening. Obviously, you folks are taking the largest step of everyone, but Arizona is, Utah is. I understand that other states are looking at this, and we in Connecticut also are planning to set up something just to explore. Goodness, to say that we're going to recommend changes is not a good idea. So I implore you, please, don't forget voluntary bar associations, voluntary metro bar associations. They are going to be the ones that carry your message. And I thank you. I really do thank you for the work that you're doing. I understand it is very important work. It is also, and I'm just going to follow up on what Professor Giller said. I was on the Ethics 2020 Commission. And if I could tell you about the vitriol and the uncivility among some of the House members when they had an opportunity to talk to some of us on the Ethics 2020 Commission. The words were, we don't even want you to talk about 5.4 or any regulatory changes. So you have to understand that in the bar community, there are some really unhappy, fearful folks that are out there. And so we need to educate them. We need to bring them along. We've got to put them at the table, and we have to have the discussion. Thank you very much.
Thank you very much.
Good afternoon, Micah Star Liberty, Liberty, like the statue. I am the president-elect of the Consumer Attorneys of California. That's a statewide trial bar. We have 3,700 members, and I stand before you in that capacity. I am also a former member of the State Bar Board of Governors. I had the privilege and honor of sitting in rooms like this, toiling away like all of you, under Presidents Bleich and Miller and Fougier and John Streeter, and I know a few things. I know, not much, but a few things. I know how hard each of you has worked on this issue. I served on task forces with Randy. I think it was 2 or 3 years, felt like 2 or 3 decades working on the COPRAC issues, but good work and hard work. And I know you all understand the mission of the State Bar, and that's public protection. And I know none of you would do anything to go against that stated mission. I also know that lawyers can be, well, Judy Johnson, who was here when I was here, used to say, lawyers are so precious. And we can be, and we are protective in a lot of ways. And because it's a profession and a calling, we take seriously what we do. And with all of that in mind, I have to say that we have 3,700 constituents. We're a political organization. So we help write legislation, we lobby our bills, much like Anthony Williams used to do for you all and Jennifer Wada. I'm sure you still have some lobbyists around. And we understand the road ahead of you all if this initiative passes, and that there will be some changes and horse trading, and that always happens. And so we'd like to offer whatever we can to help you in that process. Because every day our folks are out there representing real folks, consumers. We don't represent corporations, we don't represent insurance companies. So we know what it's like to spend time on the phone with clients who can't pay their medical bills, who are at risk of losing their homes because of fraud, who have signed away all their legal rights because they downloaded an app. And this gives us pause when we look at what's before us now. So there's a lot of questions. Are there going to be arbitration agreements with these corporations? Are we commingling funds in some way? Is this the unauthorized practice of law? You know, as a baby plaintiff's lawyer, you're so concerned about, well, first, not malpracticing. I think you spend the first 4 or 5 years worried about that. But then the other rules, sharing funds with non-lawyers, having folks practice law when they don't have a license. What do you give to the paralegal? How much oversight do you have to have? So we don't know what all the details are going to be, and we have a lot of concerns. I don't think it's fear. I think it's curiosity and some skepticism. And so at this point, we are mildly against the proposal, just to state as clear of a position as we can. We want to make sure we don't see the legal profession become like, you know, Uberized, if that's a word. And we want to make sure that we are able to get malpractice policies for a law firm that has a corporate partner, and make sure, above all else, that our real folk consumers and clients are still able to communicate with their lawyers in a confidential way. So with that, I would like to invite you all to call upon us. I'm here with our CEO. Our organization is extraordinarily interested in helping in any way we can. If you would like to meet with our lawyers, if anyone can provide data or information to you, we would like to. I thank you for your time, and we look forward to hearing from you.
Thank you very much.
Flack, Robert J., F-L-A-C-K, like the color black, not Roberta. I hesitate to follow that rather conciliatory set of comments. I'm going to be a little bit more abrupt, I think. I'm not going to be as accommodating. I think I'm not here to make friends. I've got enough friends. There are about 10,000 people that I communicate with on my LinkedIn profile. So I'm going to be a little bit abrupt. Before I get into this, I want to thank you for allowing me to talk. I want to also wish you a wonderful remaining rest of your weekend, because I may not get the chance later on. Let me give you a little bit of background, about my background. I'm not a technophobe. I have been both in-house as well as litigator in IP and corporate transactions. I was in-house at big data companies, as well as in other information technology companies. My title at a big data company, I won't name it, was Director of R&D, but it was really mergers and acquisitions, corporate development. I was CEO for a company that was involved in high-performance computing, especially as it relates to imaging and national security interests. So I'm not a technophobe. Somebody else mentioned earlier, I think it was the first speaker, that the individuals that were not official representatives here were classified as public members. And I was originally concerned about that because I did some searching on your backgrounds, and it seemed as if you were, rather than just representatives of the public, you were in fact representatives of industry, and in fact representatives of things that you would anticipate benefiting from. Now, it occurred to me that I hadn't seen as broad a group of industry representatives since having a cup of coffee at Starbucks on K Street in Washington, D.C. It seems as if you've collected people who have a particular point of view, and there's no opportunity, except for events like this, for you to come in contact with people who have other than a particular economic interest in a particular outcome. And I was concerned about that. Again, I come from the management perspective as well as a legal background. I do practice corporate and transactional law and dispute resolution litigation. I also volunteer my activities pro bono. The last case I worked on pro bono, I did it regularly, happened to be a landlord-tenant matter where the defendant was, in fact, a retired dean of a fairly prominent law school in California. And so I'm suggesting that there are lots of ways of serving, and that even though people who have a mantle of professional responsibility can, in fact, be slumlords. Not that they all are, but there's a need to protect the public from the influence of people who may not have the best of intentions. And I'm proud of my service pro bono, and I continue to do that. I come to this with a couple of kind of management paradigms. I use the Edwin Suchman model of evaluation research from this book, Evaluation Research. It starts out with structure, process, and then you look at outcome, and that's how you do your evaluation in terms of due diligence or whatever. And with financial affairs, you can do a financial analysis, then you go up and find out whether they're processing things appropriately. and to find out whether they've got the right team involved. And I think we've talked about whether we got the right team involved. I think that you've got particular interest in encouraging a technological solution to this problem, as opposed to something that may be a broader service to the community. And I'm concerned about that. I became more concerned when I heard the presentations yesterday. And let me say, again, I think I mentioned I didn't mention that I'm currently on the board of the Beal Center for Innovation and Entrepreneurship at UC Irvine. I was managing director of the Irvine Incubation Center, affiliated with the business school at UC Irvine. So I've been around the block, and I've been involved in the investment community. I was the senior vice president of Practic Venture Capital. Venture capitalists, investment bankers have what we call the BS maker. It's a way of identifying whether there's credibility in the presentation. And frankly, yesterday my BS meter was falling off the rails. Ms. Hadfield, Dr. Hadfield, is it? Started out with a presentation of the low value, tried to diminish the value of the 500 contributors who offered critical comments. And her analysis doesn't meet the standard of more traditional, more elaborate models for that kind of analysis, which I use the Sprinter model out of Glen Urbin, MIT, for those kinds of analysis. Not even close to that. The other commonly used analysis for that initial presentation of data that she provided, comparing the influence of 40 million Californians versus the 500, is the Q-score used by the entertainment industry, and there wasn't anything supporting anything that could be a comprehensive analysis of that. She moved into a complete misrepresentation of CRO, clinical research organizations in the pharmaceutical industry, and talked about the advantages of deregulation there. She talked about the resolving matters of HMOs, where HMOs did not control patient care, and that is completely divorced from reality. I'm astonished, and I was looking forward to an opportunity to rebut her while she was in the room, but there just wasn't time, and I understand that and respect that. So, again, you got the wrong people in the room. You're dealing with presentations that are full of holes, including, and I may say, the original document. I'm not prepared to talk about it, but I'll submit written comments. And I appreciate your response to that. Again, assumptions not based in fact, but based on philosophical principles. The presentation from the nice person from Stanford, what's her, Margaret Hagan. If you take a look, Margaret Hagan, Hagan, taking a look at her team, by the way, as a person who's involved in corporate development, amazing resources that she apparently has, an amazing footprint. She has a team of second-year associates and designers putting this together, trying to tell us how to practice law. And it seems as if, again, you've got the wrong people putting together the wrong process that's likely to come out with the wrong outcome. I've written a couple of headlines, particularly related to our infographics, and I'll be using those in my public comments, written comments. The headline that I wrote as it relates to her presentation was that it was like a Marvel Comics version of Practicing Law for Dummies. And I think that's my concern about reducing the practice of law to that kind of simplified graphic, where the context of the practice of law is not fully available, and it may be superficially appreciated, but it lacks substance. As I mentioned yesterday, there's a difference between selling hamburgers and providing nutrition. And sure, these things may have superficial appeal, but they don't provide nutrition. Another criticism of her presentation, she mentioned 2 research techniques. She mentioned rank scoring of attributes and convenience sampling is her convenience sampling, rank scoring of attributes and convenience sampling. Rank scoring of, let's talk about convenience sampling. That's a research technique that has been criticized since the Truman-Dewey political polling fiasco, and completely discredited. And she's apparently using that as the primary vehicle. The rank scoring of attributes is the way that the Ford produced the Edsel in such an inappropriate fashion, where attributes were dealt with in isolation from the gestalt of the entire entity. So this disaggregation is something that's possible in the tech community, but when you're talking about providing consumer services, it's completely inappropriate. And the concern is that in allowing this kind of stuff, and again, the other speaker, Dr. Hadfield, suggested we just do it. We just do something. Well, once you've scrambled the egg, you can't unscramble it. I was thinking about the kinds of warnings that are in the famous book Beyond Freedom and Dignity, where you've got and it relates to something called the Overton window, where you alter expectations and then people live with those expectations and think those are normalized. And I'm afraid that if we allow this camel under the tent and this kinds of bogus practice becomes normalized, that it's going to be difficult to go back. It seems as if what we've got here in terms of a rigid procedure that you're trying to develop, checklists, forms, is very similar to what could be considered civil law practice as opposed to our traditional common law practice. As we move away from the common law traditions that we've lived with for ages into a civil law practice, you've got an opportunity to lose tremendous flexibility and adaptation to particular subjective interests of the individual as it applies to our legal fundamentals. And I think that that's a substantial loss. You take a look at what's going on in Hong Kong right now, where there's a big challenge to their loss of a common law tradition, and there are people rioting the streets. And my sense is that this kind of subtle approach to reducing the availability of our protections of our common law system is kind of like the problem with the boiling frog. You get that frog in the water, you crank up the heat, and you don't know that it's dead until after it's too late. And my
Mr. Flack, I'm sorry to interrupt, but we've tried to keep people to around 5 minutes, and I've now let you go well more than twice that. So
I appreciate that, and I certainly don't want to take up too much time. I appreciate your willingness to hear my very challenging comments. There will be more in writing, and I wish us all luck as we find a reasonable solution to this. My solution would be different than what you seem to be suggesting. Thank you.
Thank you very much.
That's ELIEDWARDS. Making sure I have a timer. My name is Eli Edwards. I am the Emerging Technologies Research Librarian at the Santa Clara University School of Law in Silicon Valley. I am here for 3 points. One, I wanted to give my public support to Rule 3.0 or Suggestion 3.0 to have a duty of technology competence. I know that last time I looked on the public comments website, the tally was 1 to 6 against, which I think is unfortunate. I know that lawyers are afraid that it's just become one more burden for them. However, technology has become inseparable for the practice of law in many jurisdictions here in California and elsewhere. And I think that giving that impetus, making it a formal duty, will emphasize the point that you have to be competent in how you do things technologically, just as you had to be competent in how you do things in paper. It's not something you can simply shift off to the younger members of the firm or to your secretary. It's something that all lawyers should take seriously, even if you are a little bit shaky on exactly what the cloud is. Secondly, I have 2 points that are not necessarily for this task force, but things I would like to suggest for the next task force that go into the implementation. One, I think that the next task force that deals with the implementation of these rules, if they go forward, should consider the issues of disruption. I graduated in December of 2008, and in 4 years, I was never able to find a legal job because I was in an oversaturated market due to the recession. I think in this case, the Big Four will utilize these rule changes to come into this market, and while there may be benefits to that, there will indeed be a market shakeup, and if there is disruption, we should look for ways of how to help current and new attorneys deal with the disruption in the market. And finally, a lot of people have pointed out the implications of 4.5 in terms of conflict of interest. I will say that as someone who cares about privacy and lives here in Silicon Valley, my concern about the removal of 5.4 has more to do with whether or not technology companies will truly embrace 1.6, the protection of client data. We've seen the Cambridge Analytica scandal. We've seen all sorts of scandals where technology companies did not take due care and restraint with their clients' data. And for that to happen in the legal field will further vitiate and erode the confidence that the consumers have in their lawyers. If they find that their very lawyers, the people who should be protecting them, is using and monetizing their information in ways that have not been, they've not been talked about or gotten consent on. That is all. Thank you.
Thank you very much. Okay, let's open the floor for anyone else who has not spoken. Then perhaps you've not given your name to Lauren. Does anyone else wish to be heard?
Good afternoon. I am David Sasson. I'm the president of the Illinois State Bar Association.
Could you spell your name?
Sossin. Just have a quick question to the commission. I've heard a lot of testimony, and certainly we in Illinois are listening, as I think bar associations all over the state and all over the country. Our question is, was Great Britain, New Zealand, Washington, D.C., Australia have all made major changes to their system. Does this commission have any reliable data that access to justice has been enhanced in any of these jurisdictions by virtue of opening the practice of law to non-lawyers? We haven't seen it, but we're certainly willing to look at that, and we think it's a very important issue. Thank you.
Thank you. Okay, it is now, 4:25? Why don't we take a break for 5 minutes, and then we'll go back on the record and see if there's anyone else who wants to speak. right, it is now, let's see, what time is it? It's 4:35, and let me one more time open this up to find out if there's anyone else who has not yet spoken and would like to be heard at our public hearing today. All right, hearing none, we are going to wrap up this session. I can't tell you how much we appreciate all of you participating. We heard you loud and clear. We will continue to hear you as you submit written comments, which will all be considered, and we really appreciate your participation. On a point of personal privilege, I will finish this up by saying we are saying goodbye to a very dear member of this group. Greg Fortescue, who has been with us, a lawyer from the Supreme Court, is now leaving the Supreme Court and going into private practice. Greg, I can't imagine going forward doing any of this work without you anymore. It has been an absolute delight. Your judgment, your wisdom, your advice, your guidance have just been invaluable, not only in this project, but in the project that we lived through before with the revision to the rules of professional conduct. You were such an important part of both of those efforts. And so the State Bar has prepared a certificate of thanks to give you. And I can tell you this entire group really has, and for me personally, has so appreciated getting to know you and as part of this process. So we wish you all the best. You must keep in touch. We won't leave you out of this altogether. We'll look for your written comments. But we thank you for everything. And so thank you. And with that, we're adjourned.
That's unexpected. I was wondering what this will. Yeah.
Exactly.
With all my hilarious birthday cards I get from the court. They do that, you know.
Do they really?
Oh, yeah.